In today's intense courtroom moment, a woman named Miss Hutchinson finds herself standing before the judge, facing serious consequences for her actions. The charge against her is no small matter. She is accused of unlawfully carrying a weapon despite already having a prior felony conviction. In the state of Texas, this is considered a second-degree felony, a crime that could potentially send someone to prison for up to 20 years. As the hearing begins, the courtroom atmosphere quickly becomes tense. The judge carefully reviews the case while Ms. Hutchinson stands before the court. Prosecutors outline the plea agreement, recommending a 10-year sentence. However, instead of immediately sending her to prison, the state suggests a chance at community supervision. This means she could avoid prison time if she follows strict probation conditions, including regular reporting, maintaining employment, completing parenting classes, and staying out of trouble. At first, it seems like Ms. Hutchinson is being given a major opportunity to turn her life around. The judge asks her several personal questions about her family, her children, and her situation at home. The court also learns that Child Protective Services is already involved in her life, adding even more pressure for her to prove she can make better decisions. Despite everything, the judge ultimately decides to suspend the prison sentence and place her on probation. But the second chance doesn't last long. Not long after leaving the courtroom, Miss Hutchinson is brought back before the judge again. This time, the situation is far worse. She is accused of violating her probation by committing theft. When questioned in court, she admits the violation. Reports from probation officers reveal that she has barely followed any of the required conditions. She failed to secure employment and did not complete the required classes. Now the judge must make a final decision. After hearing the details and expressing frustration over her repeated mistakes, the court decides enough is enough. The motion to revoke her probation is granted, and this time the consequences are real. Ms. Hutchinson is sentenced to 4 years in prison. A second chance was given, but in the end, her own choices brought her right back to the courtroom, this time with no way out.
Your attorney, did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You understand you're charged with unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine, and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am, I did.
Outside the agreement, the state is recommending that your community supervision be for a term of 7 years. There be a TAP evaluation, 250 hours community service restitution. And if there is a drug case filed from the same date, they will take it in consideration as a part of this plea bargain agreement. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I did.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Exhibit 1 and attachments, Your Honor.
No objections, Your Honor.
All right, state, you may be excused. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA. Ms. Hutchinson does have a stable place to live. She does work part-time. She earns $14 an hour. She helps her father. It's called Ready. What was it? What is it called? Ready?
Well, we do make readies.
Make Readies. I'm sorry.
Yes.
Okay. What
Make
is that?
Readies. They clean apartments
Okay.
after the individuals leave the apartment complexes. They clean the apartment complexes, get them ready for the next tenants. So she is working part-time. So we're asking the court to follow the recommendations of the ADA She is ready to follow any of the court's sanctions. She's willing to prove to the court that she is going to comply with any of the court's directives. Also, Judge, with the $2,000 fine, since she does earn $14 an hour, if the court is willing to grant her application for probation, we're asking the court to lower the fine.
All right. And who is Lisa Lara to you?
She's my girlfriend.
Are you all still together?
Yes, ma'am.
You say yes, ma'am, and then you look to the side. Right?
Oh, yes, ma'am. We are.
All right,
she's
who are you
in the
looking
court.
for?
Because she's in the courtroom.
Okay. If you're drug tested today, what are the results going to be?
Negative.
When's the last time you used?
Well, I'm currently on the methadone program.
All right. This is what the court is going to, do you have any children?
Yes, ma'am, I do.
What are their ages?
I have a 21-year-old, a 20-year-old, and a 17-year-old.
And
And
the 17-year-old, does he or she live with you?
she lives with my father. And I am going through a CPS issue with my ex
Mhm.
to receive joint custody for my son.
All right. And then Lisa Lara, does she have any children?
Yes.
And what are their ages?
Yeah, one, a boy, he's 16.
All right. And where does the 16-year-old live?
He lives with her father.
Okay. Do you have any grandchildren?
Yes, ma'am, I do.
How many?
I have two,
And what are their ages?
5 and 6.
And do you see them?
On a regular basis. My daughter just got married and she moves to Fort in Kentucky
Okay.
with her new husband.
All right. All right. This is what the court is going to do, as previously stated. 10 years in the prison, suspended and probated for 7 years. $2,000 fine, probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting. Offense date, which is May 10th, 2024. There's to be no unsupervised contact with minors. There's to be CPS compliance. And since she's going to be under gang supervision, I know they'll do the visitation, so I'm not going to ask you all to do the visitation. There's to be regular random UAs, 250 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, 100 of those hours will be deemed satisfied. How far did you go in school?
I graduated high school, ma'am.
What are you planning on doing with the rest of your life?
Hopefully starting a business of my own soon.
I will, yes.
Excuse me. She's in parenting classes already because of CPS.
They'll confer with CPS and the court will accept those hours if it's successfully completed. All right. And the court will deduct another 100 hours if she provides proof that she's filed for a DBA.
Thank you.
Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Judge.
And previously, I don't know if it was said on the record or not, but when this plea bargain was accepted, the court did previously at that time find that there was sufficient evidence to find her guilty, and the court found her guilty. So just so the record is clear, the court did find you guilty.
Yes, ma'am.
All right, thank you. You're excused. Probation will go over conditions.
One last item.
Yes.
The court assessed minimum supervisory fees.
No, I've already probation 24 CR 007. And are you Roxanne Hutchinson?
Yes, ma'am.
All right, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am, I did.
Are you the same Roxanne Hutchinson who was placed on community supervision in 2024 CR 007949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 1, on or about the 19th day of February 2025 in Bexar County, Texas, the defendant Roxanne Hutchison committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true? The court could find it true, grant the motion, find you guilty. Grant the motion and sentence you up to 10 years in the prison
Yes, ma'am.
and up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, continue probationer on this probation in cause number 2024 CR 007949, but to amend conditions to now include state ISF cognitive track followed by ISP.
All right, what has she done on probation?
The only thing that Ms. Hutchinson has done on probation has been to provide her DNA sample as required.
She was recording. Sorry.
She was reporting. She reported last May 7th of 2025.
She had been reporting previous to that as well.
Right, I'm saying her last reporting is on that day.
All right, so here's my question. Has she done her parenting classes? All right. Did she obtain employment?
Judge, if I may
Yes.
inform the court, she was doing the parenting classes through CPS. She has a CPS plan because she's trying to get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right, so how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number 1. She knows she has a testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxanne Hutchinson.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey. I know it doesn't reflect in the probation report or whatever, but since then I've kicked heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends, so I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years.
Judge, we need and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking we pled true to number 1. You're facing 5 or facing 10. State would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right, this is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review?
The courtroom is quiet, but the tension is already building. Everyone in the room knows that the case about to unfold isn't just another routine hearing. Standing before the judge is Miss Hutchinson, a woman whose attitude throughout the proceedings immediately catches attention. The charge against her is serious, unlawfully carrying a weapon despite already having a prior felony conviction. In Texas, this is not a small offense. It's considered a second-degree felony, and the possible consequences are severe. If convicted, Ms. Hutchinson could face anywhere from 2 to 20 years in prison, along with thousands of dollars in fines. For someone already carrying the weight of a felony record, this moment could change everything. As the hearing begins, the judge carefully reviews the case file while the prosecutors outline the situation to the court. The state explains that they have reached a plea agreement with the defense. Instead of pushing for the maximum sentence, the prosecution recommends 10 years. However, the deal also includes a possibility that the prison sentence could be suspended. That means Ms. Hutchinson would not immediately go to prison. Instead, she could be placed on community supervision, also known as probation, for several years. For many defendants, this kind of offer represents a rare second chance. The terms of the agreement are strict. Ms. Hutchinson would need to follow a long list of conditions if she wants to avoid serving time behind bars. She would have to maintain steady employment, regularly report to probation officers, and complete hundreds of hours of community service. She would also be required to undergo evaluations, participate in parenting classes, and comply with various restrictions on where she can work and who she can be around. The judge listens carefully while reviewing the evidence submitted by the state. After examining the exhibits and hearing the details, the court ultimately finds that there is enough evidence to support a guilty finding. Ms. Hutchinson is officially found guilty of the charge. But instead of sending her directly to prison, the judge chooses to follow the plea agreement's recommendation. The sentence is announced: 10 years in prison. However, that sentence is suspended. Instead, Ms. Hutchinson will serve 7 years on probation. Along with that probation comes a $2,000 fine and a long list of conditions she must follow. The court makes it clear that this is not simply a warning. This is a structured opportunity to prove that she can change her behavior and stay out of trouble. The judge begins asking her several questions about her life. The conversation quickly reveals more about her personal situation. She has children, and even grandchildren. There are already ongoing issues involving child protective services, which means the court is paying very close attention to how she conducts herself moving forward. The judge emphasizes that these responsibilities make the situation even more serious. If someone has children depending on them, the expectation is that they will make better choices. Ms. Hutchinson confirms that she understands the conditions of her probation. She acknowledges that failing to follow the rules could bring her right back to court. At that moment, she has been given something many defendants never receive, a chance to avoid prison entirely. But that chance does not last long. Sometime later, Ms. Hutchinson finds herself standing in the same courtroom again. This time, the atmosphere is very different. Instead of discussing probation terms or second chances, the court is now reviewing a motion to revoke her probation. According to the probation report, she has violated the conditions set by the court. The violation is serious. She has been accused of committing theft while already on probation. When the judge asks about the allegation, Ms. Hutchinson admits that the violation is true. This admission immediately puts her probation status in serious danger. Probation officers provide additional information to the court. Their report shows that Ms. Hutchinson has not followed through with most of the requirements she originally agreed to. She has reported to probation and provided a DNA sample, but many of the other obligations remain incomplete. She has not secured stable employment. She has not completed the required parenting classes through the probation program. Her attorney attempts to clarify part of the situation. According to the defense, Ms. Hutchinson has been attending parenting classes through Child Protective Services because of an ongoing case involving her family. Even with that explanation, the overall record of compliance is extremely poor. The judge begins expressing frustration. From the court's perspective, the situation is difficult to ignore. Ms. Hutchinson had already been given a significant opportunity. Instead of serving a decade in prison, she was placed on probation with clear expectations. Yet despite that second chance, she returned to criminal activity. The judge also points out something that makes the situation even more troubling: her family responsibilities. Having children and grandchildren should have been a powerful motivation to follow the law and complete the court-ordered programs. But according to the probation reports, that motivation did not lead to meaningful change. The courtroom becomes silent as the judge considers the next decision. At this point, the court has the authority to revoke probation completely. If that happens, the original prison sentence could be enforced. The prosecutor argues that the violation proves Ms. Hutchinson is not taking the court's orders seriously. They ask the judge to grant the motion to revoke probation. The defense asks for leniency, hoping the judge might allow her another opportunity to correct her mistakes. But the judge's patience appears to be running out. After reviewing the case history, the probation reports, and the new offense, the judge delivers the ruling. The motion to revoke probation is granted. Ms. Hutchinson's probation is officially revoked. That means the protection she once had from the suspended sentence is gone. Now the court must determine how much prison time she will serve. After considering the circumstances, the judge announces the final sentence. Ms. Hutchinson will serve 4 years in prison. The judge also recommends placement in a therapeutic community program, which may provide structured rehabilitation during her time in custody. Additionally, she will receive credit for the time she has already served. With that decision, the case reaches its conclusion. What started as an opportunity to avoid prison entirely has now ended with a 4-year sentence behind bars. For many people watching, the case serves as a powerful reminder of how probation works. When courts offer probation, it isn't simply a warning, it's a strict agreement. The defendant must follow every condition carefully, because any violation can bring them back to court facing even harsher consequences. Ms. Hutchinson had that opportunity. But in the end, the choices she made after leaving the courtroom determined how the story would end. And this time, the judge made it clear that the second chance had run out.